Everyone has heard of the story of Tickle Me Elmo toys, that parents descended upon stores to buy them for their girls and boys. But the story of Tickle Me Oscar has been largely forgotten. It is the story of a lawsuit that the toy was begotten. Seeing the success of Tickle Me Elmo, Oscar the Grouch became overjoyed, because he realized he could make a profit by creating his own toy. Oscar created Tickle Me Oscar and thought it looked right, but Elmo sued for copyright infringement and wanted a court fight. Elmo sued in Kentucky, but he lost the case, even though during the trial Oscar threatened to spray him with mace. Elmo still believed Oscar stole his idea and that he should win, so he looked for another state for a new trial to begin. Elmo still wanted to stop the Oscar toys and sought production preemption, so he brought suit in New Jersey, looking for redemption. Elmo stated, "This is New Jersey, not Kentucky," so his case should not pause. But Elmo did not account for the full faith and credit clause. Full faith and credit is detailed in the U.S. Constitution, Article 4, Section 1. But a further explanation is needed before we are done. Full faith and credit means that states have to respect the public acts, records, and judicial proceedings of other states. Thus, New Jersey must respect the court decisions of Kentucky that took place on previous dates. As some time passed, Elmo tried to sue again under Oscar's nose, but his case was barred by the statute of repose. Repose cuts off certain legal rights if they are brought up after a deadline. That Elmo filed too late, Oscar thought was sublime. Seeing red the next year, Elmo sues again with no fear. Copyright infringement, the same claim he recried, but being barred by res judicata would keep it from being tried. Res judicata is like claim preclusion, Oscar sighed, and restricts litigants from relitigating on the same cause of action. When a final judgment on the merits has been made, leaving Elmo little traction. Thinking he needed a better plan, for Elmo was determined to rob Oscar of his can. This time Elmo devised a master Muppet plan. He sued under a different cause of action. Yeah, he was the man. His claim of trademark infringement might have had merit, but since final judgment had been entered regarding the issue of similarity, Elmo's suit would be barred by collateral estoppel, to be sure, also known as issue preclusion. For these doctrines apply, and there will be no cure. There was final judgment, saying it's a fact that toys ain't similar enough. So that issue is forever settled as long as the discussion to get there was thorough and tough. Even after hearing the issue was forever settled, Elmo just wouldn't quit. He decided to bring a completely different claim he thought was legit. About the entire controversy doctrine Elmo ignored. The doctrine requires claim jointer so courts don't get bored. All claims stemming from one event must be combined into one suit, even if the cause of action is independent. Parties in that suit will get the boot. The entire controversy doctrine is an affirmative defense that Oscar raised in a timely manner, so it was not waived. Oscar won yet again, this time without wasting any time in court. He could not believe that Elmo wanted a continuous fight of this sort. So Oscar won the cases and walked away in grouchy glee. But for Tickle Me Oscar, that is not the end of the story. Because Elmo's toys continued to sell while Oscar sat on the shelf, kids did not want the strange green toy that they said looked like an elf. So Oscar treated him to his garbage can and moped in a crouch. But unfortunately, that is the life for the one known as Oscar the Grouch.